And we do have this breaking news just into CNN because the Supreme Court has just issued another consequential opinion, this one in case known as Kennedy versus the Bremerton School District. This regards, and you may have seen the circumstances of this, a quiet prayer by a public school employee, a football coach in this case, whether that's protected by the First Amendment.
That's right. Our justice correspondent, Jessica Schneider, is right back with us now. You've read through, or starting to read through the opinion. This is so key because this is a ruling that really tested the boundaries of three different First Amendment rights. How did the justices come down?
Yeah, so Poppy, the court here saying that the First Amendment guaranteed that this coach could in fact pray on the 50-yard line after games. So the Supreme Court saying here in a 6-3 opinion that this high school out in Washington State violated both the free speech of this coach and also the free exercise clause when they suspended him after he wouldn't stop praying on the 50-yard line. This school had argued that it violated their school policies, that they were worried about coercion of students, and they were also worried about violating the endorsement clause of the Constitution, saying that the government can't endorse religion. They said by continuing to allow the coach to pray on the 50-yard line, they were in jeopardy of violating that clause. So they suspended the coach, and that's what set off this litigation that for years this coach has gone through the lower courts that all ruled against him. But today, the Supreme Court ruling in favor of the coach here, saying that he should have been allowed to pray on the 50-yard line. It was something that the facts were somewhat disputed here. The school had said that they had offered him alternate accommodations to maybe pray in an area that wasn't so public-facing, because the problem, the school argued, was that when the coach went to the 50-yard line, some of the students, some of the players, they felt inclined to follow him, whether or not that amounted to coercion or not. It was this public airing of this coach's religious preferences that the school was most concerned about. But now the court reiterating that this was in fact personal speech from the coach and he had every right to do it on the 50-yard line. However, Jim and Poppy, this is really amounting to a sea change in what we've seen from the court's precedent here. It was back in the 1960s that the court said that public officials couldn't mandate that students pray in schools. And then as recently as 2000, it actually invalidated a policy at a school that had a prayer over the loudspeaker before sporting events. So the court here, not exactly rolling that back, but really going a step that we haven't seen from this court, saying that private prayer in the public view of students and others at football games at a school on school grounds is okay here. So again, we've seen this court, this solidly conservative court, rule repeatedly on the side of religion, and that's what we're seeing here again today with this court ruling for this high school football coach and his rights to pray on the 50-yard line, guys.
3 days of three Supreme Court decisions, Thursday, Friday, and now today, three consequential decisions.
Yeah.
CNN Chief, thanks so much, Jessica Schneider. We're joined now by CNN Chief Legal Analyst Jeffrey Toobin, CNN Legal Analyst and Supreme Court biographer Joan Biskupic. Jeffrey, let me begin with you because I want to help people at home digest this and I wonder if we should couple this with the earlier decision regarding Maine and allowing state funds to go to religious schools here. Is this Supreme Court and the conservative majority once again expanding, in the simplest terms, religious freedom and taking away restrictions on public funding, public support for religious activities and narrowing that wall, that division between church and state?
Definitely. I mean, there are two religion clauses in the First Amendment. There is the Establishment Clause, which says, the Congress shall make no law regarding the establishment of religion. Basically, we can't have the government mandating religion. We also have the Free Exercise Clause, which says individuals have to have the freedom to exercise their religion. What's going on in all these cases is that the conservatives on the court are shrinking the Establishment Clause and expanding the Free Exercise Clause, because those two clauses, they're sometimes in tension with one another. As in this case, because the school district in this case said, look, this football coach in a position of authority is effectively showing that the football team has a state religion. But what the coach said is, no, this has nothing to do with the government or the school mandating religion. This is my free exercise of religion. Same thing happened in the Maine case. In the Maine case, the people complaining about the law said, look, giving money to parochial schools is a mandating of an establishment of a state religion. The schools said, no, you are penalizing us for being religious. You are penalizing us for our free exercise. So in both cases, free exercise won over establishment, and that's happening in case after case.
Yeah, big free exercise, small establishment is clear from this court. Joan, let me read you part of Justice Gorsuch's majority opinion. Quote, the only meaningful justification the government offered for its reprisal rested on a mistaken view that it had a duty to ferret out and suppress religious observances, even as it allows comparable secular speech. The broader question beyond Coach Kennedy is, what does this mean for opening the door to more prayer in schools? I mean, is this a complete reversal of the 92 decision of Lee versus Weissman? Is it all different now?
Well, it certainly, Poppy, calls into question everything back to 1962 when the court first said that schools could not require prayer, in schools. This is part of such a larger package of this court, and notice it was 6-3. This is the conservative supermajority. Chief Justice John Roberts was with Neil Gorsuch 100% here. It's part of a pattern that includes not just what they did in Maine, but just 2 years ago when they broadened exemptions for religious believers under the Affordable Care Act's contraceptive mandate. It's part of the pattern that included allowing religious prayers to be said at public council meetings. This implicates so many cases going back, as I say, to 1962, and not just Lee versus Weissman, the case you just mentioned from 1992, in which the court struck down prayer at graduations, where students would feel compelled to be at their own graduation, coerced to hear a religious speaker. But it was just in, I think, about 2000 where the court actually said that you couldn't have students reading prayer before football games over a loudspeaker because the school controlled the loudspeakers. The public school in this case did control the field. Coach Kennedy was someone who was a school official, even though obviously he's cast right now by this majority as saying he was acting privately. But this is a sea change on religion that follows a pattern of conservative justices who believe that conservative religion is under siege.
Let me just ask you this then, because folks at home, as with abortion, as with the gun decision, there are going to be people listening right now who have a different view. Some see it as a good result, some as a bad result. But Jeffrey Toobin, a question for you. There were multiple precedents prior to this that limited the ability of public officials to bring prayer into schools and to their public duties. There were multiple precedents, as you know, regarding Roe v. Wade and other cases with the right to privacy. Is precedent dead on the court, stare decisis? I mean, we heard every justice, when they were asked repeatedly, they talked about respect for precedent. Are we seeing that eroded here?
Yes. I mean, we are seeing the influence of the three Trump justices. I mean, as the three dissenters said in the Dobbs, the abortion case last week, the only thing that's changed is the membership of the court. There is no other change but who's on the court. The fact that Amy Coney Barrett is there and not Ruth Bader Ginsburg, and the fact that Brett Kavanaugh is there and not Anthony Kennedy. I mean, that has changed the dynamics in the court. And, this is not like Dobbs, where they are explicitly overruling a previous case, Roe v. Wade, but this is a case where they are moving the law incrementally in a very clear direction to allow more state involvement with religion. It can be with regard to prayer in schools. It can be regard to money going to religious organizations, or it can be exempting religious organizations from government mandates, like in the Hobby Lobby case about contraception. All of that is part of a package, and that's what Donald Trump promised he would deliver to the Supreme Court, and that is precisely what he did deliver to the Supreme Court.